But sir, regarding the Omidyar PDRs, did the provision give Omidyar veto powers over affairs of Rappler Holdings or Rappler Inc.?
If you read the question provision, and if you read it carefully, the question provision merely says, RH undertakes to cause Rappler Inc. not to amend its articles of incorporation without getting the approval of 2/3 of the PDR holders. So on its face, okay, it appears to be a veto power. Yeah. But legally, it is not.
How so, sir?
Why? Because it's just an undertaking of Rappler Holdings. I undertake to cause Rappler Inc. not to amend. Okay? But Rappler Inc. does not have any obligation to amend, to comply with that condition if it does not want to. So what happens if after requesting Rappler Inc. not to amend its corporation, its articles of incorporation, Rappler Inc. does not follow the instructions?
But
okay? So then Rappler Inc. will proceed, and in fact can proceed to amend its articles of incorporation even without the consent of the PDR holders, of the PDR holder, in this particular case, Omidyar. Now, what's the right of Omidyar? Okay? So, sasabihin ng Omidyar, you, Rappler Holdings, violated your undertaking. Okay? So, it merely gives Omidyar a ground to terminate the relationship. In other words, to terminate the depository receipts. Parang ano it's like I think a PDR is more akin to a commercial paper, to a loan agreement. Okay? For example, ABS-CBN or GMA Holdings or even Rappler Inc. gets a loan from a foreigner, from a foreign bank. It's a standard provision in loan agreements that the borrower, in this case either ABS-CBN, ABS-CBN, GMA, or Rappler Inc., okay, will not do certain things without the consent of the lender. That's a very standard provision. So would that make, for example, the 3 borrower companies cede control to the foreign bank? No. It's just a negative covenant. Now, what if the Philippine lender proceeds, for example, to amend its articles of incorporation and bylaws without requiring the consent of, getting the consent of the foreign lending bank? So the foreign lending bank will just declare the borrowing Philippine corporation to be in breach of the obligation. Okay, and therefore may declare it may be an event of default. But that does not necessarily mean that by including that negative covenant, the foreign bank has control or becomes the owner of ABS-CBN Holdings or ABS-CBN, GMA, or Rappler. It's basically the same thing. So if, for example, pursuant to that clause in the RH Omidyar PDR, RH is not able to get the consent of RI for whatever reason, okay, all that this question provision does is to give Omidyar a ground to give up its investment. Okay? So it should be very clear. So negative covenants are it's very common. So although this one looks like to be a veto power, it is not a veto power in the traditional sense, in the legal sense, as we understand it in corporation law. Okay? But assuming, for the sake of argument, that this is indeed a veto power, there is a Supreme Court decision which basically says that veto power does not amount to ceding control. I think it's very clear, no? That principle, I think, which is based on some congressional deliberations, would give a very good defense, good legal ground for Rappler Holdings or Rappler Inc. to question the SEC decision. Because there is a difference between control and veto power. And that itself has been recognized by the Supreme Court as a protective mechanism for investors, which is what here it says, no? Assuming that it is a veto power that we understand under Corporation Code.
But Sir, SEC argued that it was already an admitted violation when Rappler submitted a waiver on that question provision last December.
I saw the submission, the waiver, and it was carefully worded. In other words, the omidyar was saying, without admitting anything, just to lay aside the issue, we're willing to waive it, and we're waiving it.
That's what the waiver is.
Yeah, it's there. I think I saw it, and it's very expressed without admitting liability. Yeah, it's not without. Yeah, it's not. No, I think since the SEC raised an issue of it over it, then the practical thing to do was to waive it para mawala ng yung issue. Unfortunately, the SEC did not see it that way.
Did the SEC respond after Rappler submitted the waiver?
Walang as far as I know. I think the one who submitted the waiver was omidyar because it came from omidyar. I don't recall any response from the SEC. The next thing that happened was this decision.
The January 11 decision.
Yeah.
So, sir,
ngayon, sinasabi ng SEC, by including that alleged veto power, a foreigner like omidyar was given control over Rappler Inc. Okay? But there is also a Supreme Court decision that the term control refers to the election of the board of directors who, under the Corporation Code, controls and manages the corporation. So in that Supreme Court decision, I think it was Tebes versus Gamboa, the Supreme Court equated control with the power to elect the board of directors, which under the Corporation Code has the power to control and manage the corporation. In fact, the Supreme Court says, okay, a stockholder of a corporation exercises control over the corporation through the election of a director who is part of the board that controls the corporation. Okay? And the Supreme Court went on to say, one of the rights of a stockholder is the right to participate in the control or management of the corporation. This is exercised through his right to vote in the election of directors because it is the board of directors that controls or manages the corporation. So what does that mean? Insofar as the Supreme Court's control is exercised through the right to vote the members of the board of directors. A question, with this, even with this question provision, was omidyar given the right to vote in the election of the directors of Rappler Holdings or Rappler Inc.? Definitely no.